Now, for our time today, I'm a divorce lawyer, I'm a lawyer, I'm a CPA, I'm an author. It's not recording. Oh, got it. All right. So I've been doing this for 25 years. And as I like to tell people, as between the CPA world and the attorney world, I have no home. The attorneys think I'm the most conservative person on the planet. The CPAs think I'm some kind of weird mad scientist. So on a personality level, how does that fit into divorce sins and the 7 deadly sins we're going to talk about today? Very simply, most lawyers don't work from checklists. Most lawyers have a fundamental misunderstanding of money. All right. Now, what we're going to be talking about today is really a concept that's near and dear to my heart. A, B, C, D, and you need slot E or step E to have everything that's connected, everything that needs to be connected. And it's just these little pieces of the puzzle that make the difference in a divorce. And when the divorce lawyer doesn't do these things, the world comes apart. Okay. And one party gets hurt. All right. So, from a very personal level, enjoy the seminar today from the perspective of how do you prevent the closest and nearest dearest to you from getting hurt in a divorce. Okay. Now, the unfortunate flip side of this is all these tasks take time, which means money. Okay. So we're going to be assuming that there's adequate assets in this state and income in any particular state where these fundamental steps, these fundamental sins, there's value to completing them. Okay. Obviously, if somebody has no assets, no income, they're in their 2021, we're not going to be arguing about this. So we're talking about just those divorces with a significant estate. All right. Number one, failure to identify assets. I give you there the factors for property and debt division. Most lawyers do not believe that interrogatories and requests for production of documents are in fact required. Now, it is optional and it's additional work to answer them, but waiving getting interrogatory signed by the other side as far as one question, identify all assets, marital or separate. That answer must be signed under oath. Okay. Now, when I say must, I'm saying in order to avoid a deadly sin. Because if I represent a client and they haven't answered an interrogatory under oath about what assets exist, I can't knowingly help them hide assets. But I'm under no duty to audit my own client's estate. All right. Now, so we have a number of tools. We've got written discovery, interrogatories, RPDs. We can take a deposition to put the other side under oath, subpoenas, finding Quicken and other computer programs on the family computer. What I call the Holy Grail, the personal financial statements filed with banks as part of a mortgage or loan application. Very, very key. Very few people misstate or overstate, or excuse me, very few people understate their assets on a loan application. So there's a lot of different sources that we can exploit and processes to exploit to find out what we need to do to identify assets. Because before we divide property, there's 4 basic functions. 1, identifying assets. 2, classifying them as marital or separate. Valuing the assets so that we know we have an equal distribution of the net marital estate. And then actually dividing them. All right. So with this process, there needs to be a marital balance sheet, is the term most family lawyers use, but it's not a term that has a particular definition under state law. Now,
I had no clue.
so we do have some background noise there, so check if you're on mute. But also, during this presentation, I'm totally comfortable with sending me questions, and that's actually the way that we get the best and highest value. And I'm going to try to save a few minutes for questions at the end. But what I would encourage you to do is keep these materials. And if you ever run into a divorce where you're wondering whether the lawyer knows what they're doing or is doing all the things that need to be done, this is a nice little checklist. All right. So again, back to the overview here. From a balance sheet standpoint and an income statement standpoint, divorces are fairly straightforward. Okay, let's talk about the balance sheet first. Most people are okay with a divorce settlement of roughly 50-50. And why wouldn't they? Okay. Now, there are times and opportunities when we don't have a 50-50, and very few divorces are exactly at 50.00% on settlements, even when the parties intend to. Most parties don't care about the net difference between 51.49 or 52.48. They just don't, but many do. And so often I have the discussion with clients that they want the other spouse to have no more than 50.00% of the net marital estate. And we'll figure out a way to get there. But in order to know and not be guessing, we need that spreadsheet. And as we all know, most CPAs have a romantic or spiritual relationship with spreadsheets. I'm no exception to that. Because unless you do the process, identify, classify, value, how are you going to figure out your division mathematically? You're not. And that's what we're talking about, is the difference between knowing and guessing. All right. Step 4, the fourth deadly sin is failure to analyze lifestyle. So in every case where you have an extended marriage, alimony comes into play. What do we mean by extended marriage? Well, you could have alimony for a 3-year marriage. You could have alimony for a 25-year marriage. Okay, obviously. But the question is how long, how much, and what type. In order to figure out what somebody's due, you have to, when I say due, D-U-E, what you have to perform is some type of analysis of the lifestyle of the parties and how they live during the marriage. It's very, very important. So we look at husband's income, husband's projected expenses post-divorce, wife's income, and that could be an earning capacity or it could be an actual earnings history. Just depends. And then wife's projected spending after the divorce. For longer term marriages, I'd say 15 and longer. And there's no rule of thumb. It's just me talking about different age ranges. You have to go through those equations to figure out need and ability to pay. So one party could have tons of need and the other party not have the ability to pay, and there's not going to be alimony, vice versa. Now, the math that goes into that is a lifestyle analysis. And we're going to, of our presentation, we're going to cut that out for it being shorter. The lifestyle analysis, all that is a series of calculations, and they should be complex, okay, as far as sheer number of variables. But the spreadsheet formulas that go into a lifestyle analysis aren't that confusing, okay? So if you want some examples, I have that in my book, The Forensic Accounting Desk Book. There's also another book by Tracy Conan written on the lifestyle analysis that I recommend you get a copy of. And understand that for high asset, high income divorces, there's really no other way to do your analysis about alimony. You can look up case law. You can you could give me a call and give me the facts and ask me off the top of my head, what are we talking about, Mason? Let me give you an example. You tell me we got a 20-year marriage, 2 kids in high school. You've got husband that makes 250 over at FedEx, wife that makes 40 as a teacher. We're going to have some child support. We got college tuition coming up in the future, but the wife's clearly disadvantaged on income. And so we're looking at anywhere between 3,000 and 5,000 a month, probably for 12 years, or possibly alimony and futuro, depending on what the lawyers negotiate. All right. Now, I just made that up. How do I do that? Well, I've got 25 years experience worrying about what alimony can be and should be. Now, that doesn't mean what the judge is going to rule, because we don't have any other facts other than those basic ones. But we have enough case law out there to develop a range or a concept of what are we talking about for the husband's earnings, wife's earnings, and of course, flip that if the wife's making the 250. All right. Sorry if that sounded gender biased for anyone, because there's plenty of women out there that make more than men, especially in 2020. That's for sure. And power to them. I just hope I represent them in that equation. Now, so lifestyle analysis, terribly valuable and important to know, but it's an easy step to skip because lawyers are uncomfortable hiring a forensic accountant to do it, which is not advisable to go cheap. Now, step 5 on the deadly 7 sins, number 5 is failure to negotiate from a position of strength. You say to yourself, duh, Mason, why would you go into a negotiation from a position of weakness? It happens all the time. Why does it happen? Because divorce lawyers are lazy. All right. They don't want to file the simple pleadings. They don't want to do the work involved. Maybe they're just too busy and they're a solo practitioner with them and half a legal secretary trying to get through the day. Well, God help you. All right, if that's your lawyer. Because rolling into mediation, putting together the first settlement offer, the little details in a divorce is what gives parties leverage. All right. And the perception of the parties of who has the greater leverage, to a large degree, is a function of what the attorneys have done or not done, including but not limited to what they've told their client. And the simple fact about divorces, and I'm doing my Nick Saban hand gestures for you, just for those Alabama fans out there. Negotiating leverage plus patience equals victory. Okay. Even if you don't have negotiating leverage, you can manufacture something to put you in a position of success. And I hate to say it, but in my office for our internal materials, it's called the process. Yes, it's named after Coach Saban's process. But what we do is to set ourselves up for the negotiation in a way that makes the most sense and puts our client in a position to win. And we have maybe 100 different techniques. But at the bottom line is, let's know, not guess, about the marital balance sheet, identify, classify value, and we know what the division is. We're going to put together the first offer, writing it down. If we need to analyze lifestyle, we're going to analyze the lifestyle, because then we know and are not guessing what a good settlement might be. Okay. Again, most lawyers are good at doing A, B, C, D, but they forget E, to put it all together. All right. Now, pensions. This is huge, huge. 9 out of 10 people claiming to be a family lawyer have a fundamental lack of understanding what pensions are and what they do. I promise you. I promise you. Now, I've got materials in the handout to help you with some of the basics, but let's go over the ones that lawyers miss. Number one, lawyers don't know how to value a pension interest. Okay, let me say that correctly. Oh, this is fun. Most divorce lawyers refer to this as a pension valuation. We're not valuing the pension. We're valuing, strike that, we're calculating an estimated value of a pension interest. Let me say that again. We're calculating an estimated value of a pension interest. Okay. Now, that's two, without going into the entire equation, that's two net present value calculations. Okay. One, when does the payout begin? We know that. We know what the current payout is, so we can calculate that with a discount rate. And then from the day of payout to the current day, we can discount that to net present value today. All right. How do you play games with that? Real simple. Discount rate. You use one rate for one spouse and another rate for the other if they both have pensions, and you can misvalue everything the way you want. If you want to misvalue it, you can. And the other side may, when I say the other side, the opposing party and the opposing counsel may have no idea what those numbers on a page mean. I'm not kidding. It's a creepy thought that 9 out of 10 divorce lawyers are walking around not with a fundamental misunderstanding about what a pension is and how to determine its value, which means you can take advantage of people, which is why it's on the list of 7 deadly sins. How do you get a pension, an understanding of pensions? You talk to CPAs. Okay. You get them to spoon feed it to you. There's a couple of books you can read from the ABA family law section. One is the Complete Quadro Handbook. I believe it's in his 2nd edition. Fabulous book. But the other thing that is very, very scary about pensions is that they all have, and I mean all of them, have elections. No, strike that, not all of them. Most have elections that need to be made as part of the divorce process. What's an election? These are choices of either boxes, essentially, where you got to pick A or B or C. 7 out of 10 or more lawyers never deal with the elections in the divorce settlement. We do, of course, because I'm talking about it. But many leave the drafting of the quadro for later without addressing the elections. And if we took 25 Tennessee lawyers, took duct tape and strapped them to chairs, let them have their favorite beverage, either it be a margarita or some scotch, and got them good and liquored up, almost all of them, if they were honest, would tell you that they don't understand the surviving spouse election or what it means. And it's terribly important. I don't know why people don't just scream about this all the time to educate other divorce lawyers. It's not my job, but I talk about it in my book. What else do you want from me? Is that a surviving spouse election means that if the participant, the employee spouse, dies before getting into payout, the surviving spouse still gets benefits. Without that election, the non-participant spouse won't get a dime if the participant spouse dies before payout. Are you kidding me? When we're talking about box A, box B. Now, if there's a dispute about the quadro, the qualified domestic relations order that gets entered in after the divorce settlement, and there's a dispute, the judge is almost always going to say, yes, we're doing surviving spouse election. But checking that box alters the separate interest created for both parties. So if the participant spouse can figure out a way to con or otherwise hide the fact that there's no surviving spouse election in the quadro, they're going to get a lot more money than the non-participant spouse in the separate interest calculation. And I mean a lot of money. So just not checking the box doesn't just screw one spouse out of potentially getting paid any benefits ever, but it also alters the calculation by the finance people, the underwriters dealing with the division of the pension. It's just huge, and people screw it up all the time. Okay. And I got story after story I could share with you, but you don't want war stories. Trust me, you don't. Now, then the last topic, failure to consider tax consequences. Now, the materials I have in here probably predate Trump. Okay. But let's go over a couple of things that the Trump tax plan. We got chat. Hold on. The Trump tax plan brought into. Good. Now, don't forget, I can send me a chat somewhere, send me a question. I'll be glad to handle it. And then, Christy, if I don't know if they have the ability to be on the screen, but if we can, that would be great. So with the tax plan, I've got an article that's on my website that I published with the Tennessee Bar Journal sometime. Good. You do have the ability to be visible, according to Christy. That summarize the child tax credits. Now, the child tax credits are real money because it's a credit. And divorce lawyers don't understand the difference between a credit and a deduction. Now, some may, okay, if you force them to, but off the top of their head, they're probably not going to be able to tell you the subtle but important differences. But under the Trump tax plan, we've got $2,000 per kid per year. So if you got 3 kids and we're working with the mother, and let's say the mother's going to have 70% of the time. Well, she's already going to get the tax credits if she can use them. She's going to have income to use them. Well, no, not necessarily on credits, but what are you going to do with them if you have no income? And child support's not income, but alimony is. But still, you talk about 3 kids times $2,000 times an average age of 12. So that's 6 years on average. You do the math, it's real money. It pays for the lawyer's fees. Now, what happens when the father says, I want the tax credits? That's when it gets really interesting in drafting a settlement. And so figuring out what the value is and the ifs, ands, and buts is very, very challenging because of the limitations, including somewhere around $215,000 a year, I believe, ish. Don't write that down. The tax credits phase out. Okay. And it starts, I think, at 125, starting to phase out, maybe 150. I don't know. It's in my article. And Cindy McCauley, also a CPA, helped me with that. So understand that child tax credits is a great place to negotiate real money related to the kids, because many times mothers will negotiate the tax credits. Don't just assume they won't if you're working with the father. Hopefully that makes sense. Next, dependent care deduction. Now, there are times that the dependent care could be a parent or a child that you're providing support for. And there are specific criteria related to that that are non-transferable. Oh, yeah. The child tax credit is transferable between the parties. One of the requirements is that you have Form 8332, which nobody fills out for transferring the right to take the dependency deduction, much less the child tax credit. But put it in the back of your mind, Form 8332 is considered, and having the opposing spouse, the former spouse, sign it as a waiver is a requirement for taking both the dependency deduction, which is now gone, but could be brought back either next year or 2025. Completing Form 8332 is required. All right. So why not put that in your decision? Now, but dependent care credit cannot be transferred, and it can only be taken by the party paying it, and it can only be taken by the custodial parent, which in general the IRS defines as the party who pays more support. Well, when the IRS says the party that pays more support, in our world, it turns out to be the party with whom the children or child stay most of the time. So while it's not written down, an IRS agent's not going to parse if mom's got 80% or 70 or even 60% of parenting time. I doubt the agent's going to go in and say, yeah, but we got to calculate dollar by dollar who is the parent that provided more support. No, it's going to be who has more time. So that being said, and then the final important change, there is a child care credit that is pretty much like the old child care credit. But let's just skip that. That's no fun. But the big thing you've got to understand is that divorce lawyers many have not studied the new tax law. How do I know? When I represent the mother, I keep everything silent in the parenting plan and just leave the plan and just say my client gets the dependent care credit. Because, of course, we haven't updated the parenting plan form. You know why? Because doing so would take a crazy amount of time, because the whole point of the parenting plan form was keep it simple. Well, there's no way to keep it simple with the child tax credit unless mom just gets to keep them. So every time I represent mom, dads and their lawyers are not trying to negotiate child tax credits. Really. But when I represent the father, I'm going to go in there and try to get at least half, if not all of them. Okay. So that's how I know. And it's been out there for 3 years. And I ask other lawyers, what are you doing with this? And I get this glazed look over my eyes. Now, or not over their eyes, is what I perceive. Now, There are other important tax questions, and we go into this in the materials. Lawyers do not understand, and I'm talking about family lawyers now, do not understand the importance of tax bases. Now, if you think I'm full of BS, write this down and use this as a test. Ask a family lawyer what's the important difference between three assets: $1,000 in cash, $1,000 in Disney stock, and then $1,000 in an IRA mutual fund. I'm serious. Ask them to tell you the difference between those $3,000 assets. You're going to get this blank stare, and they're going to say, "What do you mean?" Really? And I'll bet you 9 out of 10 of those family lawyers, in giving the answer, will not discuss tax basis. Okay. Which is a very scary concept when lawyers are out there and their job is to divide marital estates. What I'm telling you is that very rarely do they even consider or worry about 1 ounce of bandwidth. I know I mixed metaphors there, but bear with me. Bandwidth is on my mind because if I had bandwidth, I would have been here on time. I had to switch locations because of 0 bandwidth. But back to the point. It's that serious. Okay. And I also know that because I spent a big chunk of the last 20 years giving seminars to divorce lawyers and forensic accountants in which I talk about these core concepts. And I ask the participants these questions so that I can know what they know and what they don't know. It's that wacky. All right. So the keys to a divorce and winning a divorce, there's no winning a divorce, but for purposes of this discussion and getting a more favorable settlement than the other party, what are the keys? Number 1, do your discovery, formal discovery, and require answers to interrogatories under oath. Number 2, pay attention to the difference between separate and marital property. One of the things I've just putting up on my blog is a full discussion about appreciation of separate property when that appreciation of separate property is marital versus separate. That's a whole nother hour to 3-hour discussion. Okay. I call appreciation of separate property the Forensic Accountants Full Employment Act. Right. Now, again, if you got a question, now's the time to put it in. Now, valuing assets. If there's a business, you need a business valuation expert. If there are other assets that are in play, including intellectual property assets, get somebody competent to do it. Arguably, my most valuable asset that I own ain't my house, and it ain't my IRA, which I wish was bigger, but is my website, memphisdivorce.com. I've got hundreds and hundreds of thousands of dollars invested in it, not just the design and the technical side, but the intellectual property and all the writing I have on it. Okay, so intellectual property, as we deal with divorces in 2020, can and will be more and more important over time. You got to value them, classify them, figure out your need and ability to pay math for your alimony. That'll give you the great arguments you need to make in that negotiation. And without those numbers, what are we really doing? Failure to negotiate from a position of strength. Doing that is very simple. Having your paperwork ready, being on time, not making mistakes in procedure, and looking, sounding, talking, smelling like you have the upper hand. whether you do or not. Okay. Now, get the pensions right. Make sure the 401k is right. If you've got an annuity in there, God help you if you own an annuity. What's the surrender penalty? You need to know that. You need the annuity contract. So, understanding retirement assets is something that's just vital, vital, vital. And then the taxes are so simple, but so many people get it wrong. So the question you have to ask yourself, if you got a client that's going through a divorce and you want to keep that client, you want to add value to you becoming that person's trusted advisor, which many CPAs consider and should. Because I don't want to be anybody's trusted advisor. You know why? They're going to call me. And my job right now in my 50s is try to avoid being called. Okay. That's kind of a weird thing, but kind of humorous, but kind of not. So adding value just on the tax questions and you saying, hey, what are you doing with the child tax credits? I almost can guarantee that the client you're talking to is going to go, what do you mean child tax credits? What does that have to do with anything? Because they don't know. And if you don't know, figuring out child tax credits takes 2 minutes. All right, maybe a little more than 2 minutes. But I already got what you need summarized on my website. All right. Do we have any other questions? I'm done with my presentation, the abbreviated version. Hopefully you've learned something about what divorce lawyers don't understand about divorce that hurts their own clients.
All right. So, like Miles said, if you got any questions, now would be the time to ask. So we are at our stopping point here in the presentation. Miles, thanks so much again for joining us. We really appreciate you taking the time out to speak to us, and it was a great presentation. So, thanks again.
My pleasure.
All right. For the rest of everyone, I hope you have a good rest of the day, and I hope you enjoy the weekend that's coming soon, hopefully. And we'll see you all again next month for next month's meeting. So, all right. Thank you.